Welcome to Facts in 5, a presentation of the Frutkin Law Firm. We provide our clients with legal services in the areas of business law, asset and estate planning, bankruptcy, and litigation. The Frutkin Law Firm has office locations in Phoenix and North Scottsdale. You can visit us on the web at www.frutkinlaw.com.
Let's start with the definition. What is a trust? A trust is an artificial entity, as is a corporation. A trust, like a corporation, can be the owner of real estate or other assets. It is created under a trust document, which identifies three separate parties. The person transferring property to the trust and signing the trust document is usually called the grantor. The person who receives the property, holds it in trust, and follows instructions in the documents is called the trustee. The party for whose benefit the trustee holds the property is called the beneficiary. In other words, the grantor causes the trust to be drafted and signed, and the trustee signs too. The beneficiary doesn't do anything, but the trust property is held for his or her immediate or eventual benefit. A trust can either be revocable or irrevocable. A revocable trust states that the grantor has the right to revoke the trust and the right to take the property back, and also the right to amend the trust. An irrevocable trust is just the opposite. The grantor has no retained rights to do anything, and the trust is permanently in place. What can a trust accomplish? The most common type of trust, usually associated with an estate plan, is called a living trust. The living trust is adopted at the same time that a will is prepared and signed, and it becomes a beneficiary under the will. For example, suppose that Mr. and Mrs. A have young children and quite a bit of wealth. Their wills might say that at the time of the death of the later to die of the married couple, their estate assets will pass to the trustee. Under the trust, it will be the trustee's responsibility to use the wealth that they left behind to care for the children. The trust will probably go on to say that assets remaining when the children become adults will be given to them, and the trust will cease to exist at that time. Another very common application is the irrevocable life insurance trust. It essentially acts as the owner and beneficiary of a life insurance policy. Upon the death of the insured person, the policy proceeds flow through to the trust to be administered for the benefit of family members. The important tax impact is that because the insured person did not own the policy at the time of death, the proceeds are not includable in the estate for federal estate tax purposes. As you might guess, the fact that the trust is a flexible legal form means that there will be tax implications. A trust may be a taxpayer, but it might not be. It all depends on the details of the particular trust. Generally, if the trust is revocable, that's the one that the grantor can amend or revoke, it is the grantor rather than the trust that pays any income tax due. As an example, suppose that the grantor owns rental property that he or she transfers to a revocable trust. The property continues to generate rental income. Even though the rent is paid to the trust, which owns the property, the fact that the grantor can revoke the trust at any time carries the rental income through to the tax return of the grantor. The grantor, not the trust, pays the income tax. The income is not taxed twice, by the way. It is paid either by the grantor or the trust, depending on the trust details, and not paid by both. What do we know so far? If you have young children, if you have significant amounts of life insurance, or if you have income generating real estate or other property, you should consider having a trust. In addition, there are a number of other specialized types of trusts for accomplishment of various objectives. For example, a special needs trust for a family member that's eligible for public assistance. In a typical family estate plan, a trust is likely to play an important role, and maybe more than one trust will be needed to accomplish several objectives.
Facts in 5 was brought to you by the Frutkin Law Firm. Facts in 5 is a series of short, general, informational presentations for the public. This is not legal advice. You should contact an attorney with specific questions regarding your particular situation. For more information, visit us on the web at www.frutkinlaw.com.